Good afternoon. When this kind of crime visits a family, every word that the defense has to say, every motion, every argument can only seem like minimization of the pain to the family and the survivors. But we can't go backwards in time. We can't undo the action. The only thing that we can do today is answer the question of a sentence. And that's whether Aiden would be sentenced to life in prison with a review in 25 years or 40 years with a review in 25 years. And with that in mind, what I'm going to do is walk the court through what the court knows already, and that's statute 921.1401. So looking at that first prong, the circumstance of the crime, of the offense. 14 years old, 114 stab wounds. Those are numbers. They're not insignificant, but they're numbers. A child is now before the court for the life that he took of another child. Horrific, heinous, horrible are just some of the words that have floated around regarding this offense. But we still have to look at the circumstances. The state had presented, or had put in the court file, a photo of the scene, of the neighborhood, and the many lakes or retention ponds in the neighborhood, the many homes and residences in the neighborhood. And what did Aiden do before and after? There's the walking past all those Ring cameras, the running back with the bloody shoes before those Ring cameras, all the different retention ponds that he could have thrown the knife, the clothes, the shoes. No. Threw the knife right there in the closest retention pond and took the shoes back home with him. And then the location matters. It's a spot that the kids had gone to before and visited in the past. A spot that wasn't covered in terms of there's a lot of vegetation there, a lot of palm fronds. There's no effort to hide the body in terms of covering it or burying it. There was no effort to conceal the decedent in terms of removing hands, removing head. All the things that could have been done to disfigure and hide the identity was not taken by Aiden Fucci. Was the crime heinous? Yes. Was that a terrible act? Terrible doesn't begin to describe it. But there are other things that he could have done to cover up this offense that he didn't take. (921-1401) 2B. The effect on the family and the community. And to this, there's no question. None. Fundraisers, vigils, letters. The court heard from the family and the community this morning. And Aiden's family. His grandmother, who tearfully expressed the loss to her family and prayers that she and the rest of the family have for the Baileys. But Your Honor, I have to quote Francis Bacon, an observer of revenge. Revenge is a kind of wild justice which the more man's nature runs to, the more ought the law to weed out. And looking to the effect of this on the family and the community, revenge and the calls for it are not appropriate. We use the law and we look to the law in how to sentence Aiden Fucci. Whether 25 review after a 40-year sentence or a 25-year review and a life sentence. So subsection C, and there's been a lot of testimony on this regarding the defendant's age, maturity, intellectual capacity. He's 14. Now today he's 16 before the court, but at the time of this offense he was 14. And some say he's mature. And Dr. Bloomfield rightly pointed out, by what measure? Who do you compare him to? How do you measure maturity? Your Honor saw the video clip of him in the back seat of the vehicle throwing up a peace sign. That's not maturity. To his mental health, there can be no question it's an issue. Telling friends that he hears voices, telling the DJJ officer Barton that he hears voices, and the antipsychotic drugs that he is on, lithium, Remron, Cyprexa. Yes, he has issues. But the focus is his age, his maturity at the time of the offense. He was not mentally well. He was not mature for his age. The actions of Aiden and his friends and the risky behavior that these children were involved in points to immaturity. A 14-year-old isn't a late adolescent, but an early adolescent, Your Honor. And you've heard both Pritchard and Bloomfield in agreement about the brain science, that a child that age doesn't have a fully formed brain, that the part of the brain that's involved with risk assessment, the prefrontal cortex, is the last part of the brain to develop. And why is that important? Children do not make sound decisions, reasoned decisions, or wise decisions. Nothing in this offense points to maturity or assessment of the risk, despite what the state would argue to the court. But he will mature, and the brain will form. It's the same with that prefrontal cortex. We're already seeing forms of maturity in Aiden. February 6th, he apologized. That was the first chance that he had that the defense team would allow for him to say something in open court. And members of the family don't accept it. And what apology could he present that would be acceptable? It's understandable why they don't accept the apology, Your Honor. But the child who highest grade level completed is 7th grade. Arrested in the 8th grade, not reading at grade level. Presented in his own words the best he could. So Dr. Pritchard had much to say about Aiden. And yes, Dr. Bloomfield was contesting certain portions of it. Interesting though still that both of them are in agreement on brain development and that these issues aren't in debate, whether it's psychology or psychiatry or social workers or even pediatricians, that they're all in agreement about children and their brain development and their ability to think through and assess the risk. And I come back to risk while we're talking about this section of the statute of mental health, because the risky behavior that we saw Aiden participate that night was carried through. It didn't start and end with Tristan's death. There's risky behavior in his out of the home after midnight, which his mother didn't know about. The risky behavior was going to a friend's house and smoking marijuana. The risky behavior continued and continued and continued because he's a child. But Dr. Pritchard argued, or stated, I should say, before the court, that he's mature. But that's not what the evidence is showing. Dr. Pritchard relied on the collateral information in terms of the other children. The other children who had their own problems of anxiety and depression and their own risky behavior. Dr. Pritchard said that his actions were premeditated based on the conversation with the girlfriend, and that it wasn't impetuous. Tossing the knife into the pond, he didn't think was impetuous. But it was. The pond was right there. Some forethought. He could have taken all of the incriminating evidence and placed it somewhere else, but most of it he brought to his home. And Dr. Pritchard said that he lacked remorse, and on this, above all, I have to disagree. Because Aiden has expressed remorse. The court has the letter. Again, it is not the most articulate letter, but it's his words and his writing. And he did that this year at 16 as his best expression of an apology, which over time will improve. As he matures, as he grows older, he'll be in a position to better express himself. And then Dr. Pritchard said that he had a poor prognosis for rehabilitation, but I'll come back to that one. So turning to subsection D, family background. Now Aiden comes from a fairly large family. He, from his mother's side, is the middle child. He's one of 5. On his father's side is a large number of children there too. So as the middle child, his grandmother described him as silly, happy, fun, and respectful. This is the kid that she would gather with the other children in the summers, take to church, have outings, go fishing. Aiden's family loves him, and they care for him, and they don't understand what happened. Both of his parents have provided letters. But what was his daily life like? And there's conflict. We hear from the same girlfriend that he was neglected emotionally, that his father is physically abusive. And then there's the constant movement. Every Tuesday and Thursday and every other weekend, he was in a different house. And it's born out of love. They loved him and they wanted to spend time with him, so that's why there's so much movement. But a child needs consistency. And he didn't have that with the constant movement between the two different homes. Part of the reason why he's late for school is because of the distances that he had to travel to get to school on time. And it's not a complaint. It's just pointing it out, that his background and the complexity of it. But within that background is mental illness. So his grandmother also testified about his uncle. And the uncle at 14, the same age that Aiden was at the time of this crime, was Baker acted and struggles with depression. That his grandfather had some mental illness issues that were so great that she separated the children, his mother and uncle, from the grandfather. So there is a family history of mental illness. And Your Honor, I point these out because it's within the statute. I'm not pointing these out as excuses. Aiden has entered a guilty plea. So turning to subsection F, Aiden stood alone and entered that guilty plea. And the apology. (921-1401) subsection G. Peer pressure, familiar pressure. We know that he was, again, with the children and the risky behavior. We know that there was drug use that night. That it is reported that he had smoked marijuana that evening before walking down or walking off with Tristan. So 921-1401, 2H, that there's no criminal history, and there is none. He has no prior arrest, no prior contact with law enforcement, and the minor infractions in the school were resolved with detention or some sort of in-school discipline. But never inside that school setting was it an issue of a red flag is how they were described. Issues where law enforcement is contacted and arrest is made. Any issues that they had with Aiden never rose to criminal conduct or an arrest. But in candor, yes, there's illicit drug use and there are allegations of drinking, not in school, but underage drinking, that are part of who Aiden Fucci is and was. Subsection I is the effect, if any, of characteristics attributable to the defendant's youth or judgment. So here we have a demonstrated lack of judgment that can be completely attributable to his age of 14. A child in middle school who's struggling academically. And his actions are a full demonstration of a lack of judgment in his actions with his peers and the results of his actions. It matters that we're dealing with a 14-year-old, Your Honor. And what do we do with a 14-year-old? He's been direct filed, and he's been brought before the court with these adult charges on an indictment. But the court still has the opportunity to consider his age and give him a term of years. And it does make a difference in terms of the life sentence versus 40 years. Because the court has heard from Raul Banasco in terms of what the Florida Department of Corrections and the resources available and the targeting of those resources to inmates that actually have a release date. At 14, he goes to the Department of Corrections without completing the 8th grade, again with a reading level and academic level that was scoring below 8th grade. No skills, no skill set. All of those that he would have to learn in prison. With a term of years, he'd actually be in a position where they could place him into one of those programs. He loves working with cars like his father. And that opportunity to learn a skill so that when he reaches his 25-year review, he would actually have an opportunity to present himself as a skilled or some sort of skilled trade would be another reason why to give him a term of years versus a life sentence. But then there's the other half. It's not just that he has no working skills at this point. If he's given that opportunity of a term of years, he can receive programs for rehabilitation. And this is a child that does listen to authority and respond well, because we saw that in his interactions with Dean Wetjen and Officer Beasley. So this statute does not bind the court. The court can, it is a non-exhaustive list. So there are factors that the court can consider, whether it's his grandmother's discussing his faith or his good behavior in court, or that he's loved by his family and that he loves his family. His little sister who longs to figure out what's going on with him and where he is, shows that he is able and capable of forming loving relationships, that he's able and capable to care for others. The court can look out and not see his father and not see his mother on his request that they don't appear, because he is well aware of all the negative press and harm that his actions have had on his family, on his father's employment, that even his mother and his mother's family had to move, and he didn't want any further harm should they even come to court. The court can consider that he had a diagnosis that was not followed up of ADHD, that the schools that did a phenomenal job weren't in a position to provide him with intellectual testing, to provide him with counseling and therapy that he desperately needed. And how do we know that he desperately needed therapy? because at 14, his recreational time was spent smoking marijuana and drinking alcohol with friends. And that he started before this offense. That within the school, in the school records, it's identified that there were behavioral issues, and yet no therapy was provided specific to that. So Aiden is presenting as disabled, and the full depth of it, we don't know. It's based on the records. We know that he had issues with auditory and speech that were not fully developed or fully examined in the school, and that he had a language-based learning disability. And that the school psychologist that was within the IEP wasn't a psychologist in the sense of a trained professional. And I don't mean in the sense of 40 years like Dr. Pritchard or in excess of 40 years like Dr. Bloomfield. She had a bachelor's degree, not a master's or a doctorate. Perhaps had she had one, she would have recommended the testing that Aiden didn't receive in the schools. That wasn't followed up on as suggested by his pediatrician. So, Your Honor, turning to 921, 1401, subsection J. He's 14 and he's presumed to have a potential for rehabilitation. And I do understand that Dr. Pritchard thinks not, but he does. We have the example that has been testified to by Dean Wetchin, that in the school setting, given an opportunity for the mentoring between Dean Wetchin and Officer Beasley that demanded respect as the officer and the dean, that Aiden responded well. That given an opportunity to express himself or deal with behavioral issues by going to them, he did that, and there was a noticeable difference in terms of the disciplinary issues that they had at the school. In Department of Corrections, can he be rehabilitated? Yes. And the best way for that to happen would be with a term of years. With a term of years, you'd have access to programs for counseling, for mentorship, and for skills. Again, he's going in with nothing. Absolutely nothing. He doesn't know how to fix a car. He doesn't know how to do anything electrical. He has no skill sets. So given that ability to get the term of years and get into one of those programs that would allow him to improve would be a benefit. Not just to Aiden, but to everyone. So what is the court to do with Aiden Fucci? Would sentencing him to 40 years diminish or take away from the 114 stab wounds? And I submit no. 40 years is not a light sentence. It is not an easy sentence. It is a 40-year sentence that this child will be placed in the Department of Corrections with grown men who have experience in the Department of Corrections. And Raul Bonasco had described the need to keep children separated and protected. But that protection only lasts for about a year. Nothing moving forward for Aiden Fucci will be easy, and it shouldn't be. And it shouldn't be. But the 40-year sentence doesn't make light of what happened on Mother's Day in 2021. It still is punishment. That every day that he's in custody, away from his friends, away from his family, is punishment. Every day being told where to go, what to do, and when to do it is punishment. Your Honor, we are talking about a prison sentence for a child and asking for 40 years as punishment. For a child that came before the court and pled guilty, not to a lesser, but pled guilty as charged. The family this morning referred to him as less than human and not human. The court cannot do that. That is not a factor under 921-1401. But the court can punish Aiden Fucci with a prison sentence of 40 years. And that's what we're asking, Your Honor. We're not asking for a release, but the child that is before the court today, that is loved by his family, we're asking for a 40-year sentence with a 25-year review. Thank you.
Thank you, counsel.